then afterwards you are having certain kind of rights which has been inbuilt in that. So that is why the thing is the patent, it is necessary to get it registered also, and it has been good for each and every people as if we get certain innovation things. So it becomes easy for us also to cap it out. Now as if I said you fridge also. Fridge, why we require the fridge for the current? So why the people have thought, the person while preparing a fridge, he thought about it, that the thing is for the certain period of time the people will be becomes more easier, and the people as if we are into the current day to day life, we are like moving here and there. So that is what, if this kind of a system if we are having out, so we can store certain food for certain food articles for the longer period of time. The people will become like easy, for the people it will become easy. So means as if that's what I develop with a certain kind of a new innovative idea. So that is why I need to make it develop certain kind of a new innovations. So that is why it is necessary for the human life to survive into their current world also. So nowadays what, as if we are having the new technology, so we are like very happiest right now, because as if we are getting a new technology, so we are getting like much freedoms in each and everyone. We are not wasting our time, like whatever we are getting out, like we are updating out. So with the help of new innovative ideas, you not need to think about for the longer period of time. So this is what it was there. Then afterwards here it is what role do the patent play in everyday's life? Now this is like a common way what we have discussed previously, as it has been said about it, like previously I have even highlighted here, the prevent affect every aspect of human life, then after publicly disclose information, enrich the total body of technical knowledge in the world, then after further creativity and innovations. So why, what plays, like as if I register my certain innovative ideas as a patent, okay, so what I get the rights. Okay. 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 Shall I start? Okay. 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 Now, as we are like little bit, I'll just before that I'll just move it out with a further slide. So at least what you people will be available on that time, like you will be getting out how this patent act it has been registered in previous way. So at least what it will be good for you also to understand, like previously I will be moving it. So at least what little bit like patent you will be getting to know. As we have learned those matters also, but once again I'll be moving with the help of the patent. Okay. So as the patent, like we got to know about it, what you mean by patent, which is something new, which is having certain kind of innovative ideas, which are developing, which is developing very new ideas, new creativity, and exactly you are having the exclusive rights, means there's a different right which you're having now. So that is why the thing is what the owners are getting certain kind of it like properties, that yes, this is the new thing which I had developed it out. And even I given you the example of like a Galileo also, that he discovered certain kind of a telescope. With the help of developing a telescope, now when the thing is you want to see an eclipse, now the thing is it has become very good for the people who are like learning with the help of geography or learning certain kind of it scientifically methods. So as this means the most important, this is only just the patent why we are registering according to the Act of 1970, because what to get about the knowledge about the longer period, and even we are having certain kind of exclusive rights, means I have built it this kind of a new innovative ideas, and then afterwards you are showing certain kind of a rights as I had developing certain kind of a new technology into it. And then afterwards the thing is once you're getting registering, means once you're developing certain new thing, so like the thing is for this you require max to max the 20 years which has been there. Okay, now just a minute, I'll just wind it up. Okay, like whatever it is, like for this you getting certain part of it like 20 years renewal you need to do it, means whatever the license which is given from the state government, so like that state government, this license will be for the 20 years, and once you're completing with the 20 years you need to renewal it out. So then afterwards we went with the help of the rights. Now here we have learned currently with the help of it, like it should be an exclusive rights, means it will be like a simple rights, means as if it has been said, means I have prepared it out. My main motive it is what I have prepared it out. So that is why it has been said in the previous, now it will be a monopoly. So like whatever I'm selling, whatever I'm making out, that all the things will be either it goes personally with me, or else it is my agent who do with the help of this type of transaction. Now next it is what with the help of it, like as if I have any kind of it problem when related with the patent. Now as been related with the help of Samsung and with the help of Micromax, we have learned with it. So that the Samsung model was same copied out with the help of the Micromax. So now certain period of time the thing is done. Afterwards the Samsung had filed a case with the help of Micromax that the thing is there they have copied out my all function, and with the help of same functions, the same model, same function, and they are just they only print it out with the help of the logo, with the help of Micromax. So if there this kind of it also been there, so according to this act, the thing is the people can what the people can register, or else they can file the case according to the other either party, like whoever it has been copied out. So that is why the thing is this has been given certain kind of a new challenges to it for this act. Either that party or either the third parties can be inbuilt it for this for the further period of time. Now as if we went with it, why the patent it has been necessary? Why the patent has been necessary? The most important it is what where you get certain innovative ideas, you get a certain innovative things to be used into the current world. As we people are aware with the help of cell phones, means this is an innovative what are the electronic items like what we are having about it, like telescope, computers, we are having a cell phones. Even currently we have given examples of with the help of the like refrigerators also. Currently even washing machines also. So this is what are like a different ideas. Even the air conditions. So like where the air conditions, like you can see it was a huge and very weighted. Nowadays like you are having a split ACs, and with the help of split ACs like you can cool also, you can make it little bit on the normal level also. In the previous time it is what you need to switch it out that thing. Even you was having the same thing. I can give one more example of an LED, of a TV also. Like previously we were having that square like TV which was having out, it was a very heavy weightage, but currently we are having a LED which has been like, which is a smaller pay, where the thing is like the wires are not used, the internal materials are not used. The TV is there, but the thing is you have developed certain kind of it innovative ideas. So this is what yet now you can say like my TV was not the dabba wala TV. Currently I can say it is one type of an LED TV which you can say. So nowadays what we as that is why the thing is we require a patent to be get it registered, because as if the more necessary it is what we get it certain kind of a new ideas, and with the help of new ideas you can develop your new techniques, new thoughts and all. So that is why we are getting registered with the help of the patent. Now there is the thing is what now this what are the roles what you participated, what roles do patent plays in our everyday life. Now as if we are like well versed with the new technology every day, as currently we are having the iMac also. Currently as if we went with the help of currently like people will be aware of Apple also. Apple computers means it is a wireless like mouse and a small pretty like you can say a keyboard which has been there. So it becomes like it is like a wireless, you can't even it's a wireless like you can just carry it on, very very like lightweighted it is. And you can see a wireless mouse also, means as if the mouse how it has been there for the computer. Now for the Apple like you don't have a mouse, you have the mouse but it is a wireless, like you can place anywhere. And the variation which is being shown in is you are having the computers, but in the computers you are showing a certain kind of a variation. So like nowadays what we are good into the technology. Nowadays we are good into technology, and as if we are staying into the current life with the help of the technology. Now as if we want like new things, new things which has been innovative, like where we won't waste our time more. So that is why the thing is the patent plays most important role, because as if we get to the new technology fatafat say, so like we mostly we participate on that thing. Now currently also we are having that roti maker also what we are getting out. That's a new thing. That's a new innovative ideas where you're getting out. So like only just you needed to put it out the ready the you can put certain kind of it like batters into that, and then after a certain period of time the thing is you're getting your chappa, your roti is also ready with it. Means as if we are having the oven. Now this is what an innovative idea. So currently with our day-to-day life the thing is our human wants are increased, and with the help of that wants also we are developing with the help of new technology. So that is why the thing is what we make it ourselves that way, so that each and every new technology, like we perform that way, that the thing is each and every technology every day is life, we make it the habitual one. So that is why the thing is this plays an important role, a patent plays an important role into it. So as you people have got to know about it, what you mean by patent. Okay, now this is what the second way, how the patent is granted. Now here the thing is you will be learning about it, where how you get it a patent, when what are the steps of filing the case, and how you develop a new technology. Now, as if we went with the previous slides, we got to know what is patent, how is something new, certain innovative ideas, what we are doing about it, and how which has been there in our day-to-day life. Now, how you granted a license. Now, for getting the license, first you need to fill it about an application form. See, I bolded here. First, the steps is securing the patent in the filing of a patent application. Then, after the patent application generally contains the title of invention as well as indications of the technical field. Means these 2 points you need to identify. First, it is what you need to file it out one application form which has been given according to the Patents Act. You need to go to the state government, and then afterwards the thing is you need to inform that this kind of innovations I have done, and then afterwards their technical terms, the technical way. Afterwards they'll be checking out like what are the terms you are, what are the wires, what are the electrical switch you have put in that, what is the innovation thing that this thing happens. They just afterwards. The first previously it is what you need to just file it out according to the Patent Act 1970. Once you're filing out with this, then afterwards you need to mention about that what kind of new invention you have done. Once you have of it, you have written that new invention. Second part it is what you need to mention about it, what type of technical items you have put in that, where you're developing certain new things. So that thing also you need to mention. Then afterwards, it must be include a background and a description of invention, clearly language, and encourage and enough detail that is individual would be average understanding of the fields could be reproduced for the invention. So this is what it has been said, means you need to just give the long interventions, that what type of innovations you have done, what type of inventions you have done, like what are the items you have put when you have done certain kind of invention. For example, you have you have used certain kind of wires, or certain kind of switches on that, or certain kind of technical wires what you have put, or certain kind of functions whatever you have attached it. Means you need to just give the clear cut difference here, the clear cut description with the help of the common languages. So it's like when granting a patent, when granting a patent, so that other parties can know about it, what type of invention he has put, what type of innovative, what are chemicals they have been put in inside. So then afterwards only the thing is they'll be granting you the certain kind of a patent, because the other party, when the state government, if they, because what once you do it out with this, once you file it out this thing, your invention goes for the R&D. Goes for the R&D, that is called the research development. It goes where they see it out how the patent, how means whatever like you have written, the same matter it has been there on it when you are getting a certain kind of an invention. They are checking out if the same it has been there, and if where the thing is where you are not harvested any kind of plants, any kind of human beings, any kind of like trees, or any kind of any kind of living organs. If you are not disordered, and then after you have prepared that kind of it, then only the patent it has been registered. Even not with this, even if the same to same, it is previously the product it has been innovative or, so then afterwards again you are innovative, again the thing is you are getting registered, so it won't be getting a registration. Means there is a long process when you are doing any kind of registrations, when you are developing with the help of the patent. As you want to make it the patent, means this thing I have prepared out, if you want to do it out, it takes a longer process. So that is why the thing is you need to give the clear description with this one. Then afterwards next it is what you need to visualize, that I said to you. Visualize and material means you need to show the help of the diagram. This is the product which I built it out, and then afterwards this is the way I need to do it out. Means you need to show the visualization also, and you need to show the like a physical way also you need to show that kind of product, so that the thing is the people will get to know when they're getting a patent. So means you need to draw it out an internal, like whatever the materials you have used, how it has been used, that all you need to require. Means the total information you need to give it out. And once you're giving that kind of information, finally they have been wind it up, then afterwards you'll be getting a patent. Your name will be registered according to the Patent Act 1970. So these are the way, where the three way you need to follow it out. Now, what are silent features? Now, there are certain features. Now, first it is what elaborating the definitions of invention. Now, what are features? Simple. It is what it's a one type of inventions. It has been said. Then afterwards, it is what the patent for the drugs. Now, abortions of the product plants, product patent for the drugs and the medicine, including certain class of chemicals. Now, for this, all the things it is one, it has been said abolitions. Abolitions means it is not at all accepted. Where certain you do the innovations where you are using certain kind of drugs, certain kind of chemicals, or certain kind of it like medicines, where the thing is what you are destroying certain kind of it elements, and then afterwards you are inbuilding certain, you are reproducing something. So where the thing is the product, it has been not, it has been abolished down. Next, it is what where if there is certain kind of an invention, you need to give it where which is not where it has been where you are harassing any kind of it plants or any kind of it organs. Then afterwards, it has been not patentable. It has been said, means you need to show the description of it properly. Then only you can do the patent. Then afterwards, next it is what more elaborated provision for the patent of addition. Okay, you need to give the more descriptions of a patent, like whenever it is being granted. Enlargement of a ground for the revocation of a patent. If for the certain period of time when you're getting a registration, sorry, not getting a registration, by filling the application forms and rest of all the documents when you're submitting out. So when they are doing R&D, if they are doing revocations, if they are cancelling out your patent patent applications or patent registration, then ultimately that also it will be given into the written why he has not at all accepted out that thing also. Strictly strike a requirement regarding assignment and transfer of the patent. Provision for the compulsory license, it has been there. License of rights and revocation of the patent on the ground of the non-working. Means as if once you're getting a registration, then only the thing is you can start it up with the patent. At the time, if they are revocating out, means as if you are not getting any kind of it, registration. So till the time you don't get a registration, you are not at all, you don't have any kind of its exclusive patentable rights. Once you get it a license, once you're getting registered, then only you will be getting a right. So like mandatory, that this is the most important, like whenever you're performing any kind of it patent, so these are the characteristics you need to follow. As if without license, you can't run it out any kind of it patent. Means with this, you require the license, and with the help of license only you can run the inventions, you can sell it out that kind of invention, which you can develop certain new technology into the each and every people's life. So this is most important. Then afterwards, here it is being given a bill which has been passed from the Parliament on the May 2002. Okay, which has been said. Now here you are having a different categories where the thing is it has been said where the thing is internally the it is not at all patentable. Now where it has been said discovery of any living things or non-living things, whatever I said you yesterday now only. Substances occurs in the nature, process of diagnosis, therapeutic treatment of human, animals and plants and animals and other microorganisms in whole or any part. Mathematical or a business methods or a computer's program and algorithmic. Now, if this kind of it has been not at all, it has been strictly said where it has been not at all patentable, okay, where you are using a certain kind of, you need to show certain kind of a logical terms so that other people can understand. Now, means for example, now you, as if you say medicines are not patentable because what it happens like when they prepare a medicines, they use certain kind of chemicals and certain kind of new animals fat which they are using out, and that fat they are putting out into the medicines and all, and then afterwards they are converting that thing and they are preparing a medicines. Even to the cosmetics, as if you are using a lipsticks or any kind of it like cosmetic items. So in that cosmetic items also they are putting certain kind of it animal skins or animals shrubs or animals fats they are putting about it, so that you get the flavors. The fish oils they are putting about it. So as if they are putting out that much thing. So as if with this only they are getting a flavors. So that is why the thing is, if this thing it has been there, so it has been said it is not at all patentable previously only. Where you are harassing any kind of plants or any kind of organism, microorganism, so ultimately it is not at all patentable according to this bill. It has been said according to the 2002. So here it is in boldly, I have just written here new additions to the non-patentable, means here the thing is it has been not at all patentable where you are harassing any kind of it like animals and all. As if there are certain therapies where means as if you do any kind of massage also. So like there are certain kind of even therapies also where they are using animal skins or animal oils or any kind of animal fat, where the thing is it has been given for the massage or any kind of treatment which is being given to the human being. So means as if they're dying certain kind of fit animals, and then afterwards once the animal has been dead, they're taking out that fat into their body, and then afterwards they're using certain kind of it to the human beings. So means if this type of means it's an innovative one, but it is good for it certain period of time, it is good for it. But the thing is what, as if you're dying any kind of human, and then afterwards the thing is you are preparing certain kind of new thing. So there the thing is it is won't at all, it is not at all patentable. So whenever if you're doing that kind of it, so it won't be registered. You're registered only, it won't be applicable. The further whatever it is means, as if you're harassing any kind of it, microorganism or any kind of it organism, so it is not at all patentable. Now next it is what the term of the patent year it has been given, as we have seen right now only it is a 20 years. Okay. Now the thing is what the term of patent will now be changed to the 20 years from the date of the filing on an application. Now when it will be applicable, the date when you get it out the application, when you file it out the application, from that time the thing is end till 20 years the thing is it has been valid from the date when you get it registered. Now currently, a term for the methods of the process of manufacturing of foods, drugs, medicines capable of being used in above is 5 years from the date of sealing or 7 years from the date of patent, whichever is shorter. So like as if you're getting out certain kind of a drugs and all, there also you get it the rights, okay, for manufacturing or certain kind of methods when you get in, but you doesn't get a rights, you doesn't get a patent for the longer period of time, as if how this patent is getting for the 20 years also, but yours like as if you're getting 5 years or a 7 years whenever it is being get it out. Now mostly they doesn't give it, but according to the new bill which has been passed for the currently, previously they was not giving for the any rights where related with the help of it, like you're destroying any kind of organism, but then afterwards as if the medicines are there, so that person should be also registered as if it's a certain kind of a drugs or any kind of medicines whenever it has been there. So if that kind of a chemical it has been given to it, so they have been said give them the at least 5 years or a 7 years or whichever will be the shorter one you can give it out. Okay, in all other case a period of 14 years from the date of the patent. Now in the rest of all the items like it is given 14 years for the patent from the date where the application has been done. So this is what the terms where it has been done. Now what do you mean by invention? Invention what it has been means a new and useful, which has been new and which has been useful in our day-to-day life, or is like which has been useful for a like a certain current period of time. So it is what involves first is one art process methods of or manners of manufacturing, machines, apparatus and other articles, substances produced by for manufacturing, including any kind of new and useful improvement of them, and allied invention. Means invention it is what which is new and something which is what which is useful for our day-to-day life, means as if it is a certain kind of it art which is being said, okay, where the thing is you are using certain kind of methods for the longer period of time, and once you are using that kind of method, so it is being used for the people where you're developing certain kind of new development, and it is being used for the each and every people. That is why we do with the help of the invention. So the main concept of the inventions it has been given here, where the thing is, it's now provided that claim or a claim related to the single invention or a group of inventions can be linked so as to form a single invention. Thus, say I have bolded out this thing, a group of invention linked to the single invention concept can be covered in the single application. So like as if the group of the people also comes together and they have invented certain kind of new ideas, so that also comes into the certain part of it inventions. They have developed certain kind of new techniques into that, certain kind of new variations and all. Certain kind of a new development and new kind of variations and all, and then afterwards developing certain kind of a new inventing concepts. So these are what are the burden proof here it has been given, as if the simple way as any kind of matter it has been there. Currently only we have went with the current previous only we have learned into the previous slides also. If there is any currently if there is any kind of it like problems when related with any kind of it certain kind of it like patent if it has been copied by same to same it has been copied. So then again what you can do it out again, the thing is you can file it the case to the court, and then afterwards whatever the permission has been given from the court, that permissions you can take it out, and then afterwards finally you can wind it up with the help of it, like you can close it on that thing. So if there is any kind of it, that kind of it, like you can just file it on the case, and then after whatever the certain period of time you get it the return, you can accept it that kind of return. So in the case of the process, patent once the patentee provide the infringement product is identical and his patent product burden on provided that the patentee process is non-violence, is non-allied the infringement. So it has been said previously only if same to same invention is already the invention is done. So again the thing is the same invention if it has been done once again. So the thing is you won't be getting any kind of rights, it won't be getting any kind of a registration. So for getting a registration, the thing is ultimately you need to show certain kind of it inventions. You can show certain kind of it invention. So as if same if it has been copied out and as if you're getting out as if you're filing any kind of case. So like priorly the thing is you can file it out that thing into the court, so that the court will be moving about it for the proof and all, he'll be doing investigation for this as if it is, because it's a one type of an illegally offense if any of the persons if any of the person copying out that same substances then too. Okay, then after parallelly import it has been said, first it is a one type of it like IPR which has been there, that is called a one type of it, one concept which has been dealing with the help of the intellectual property rights, and as if it is intellectual property rights, it's a one type of the exclusive rights, means as if it's an individual rights where not a single person has been there, means he has developed a new, means it has been registered that yes this is developed by myself, and with the help of that only I can make no I have the rights to making, selling and distributing all the products using the process. I can like the same way I can like make it out certain product, I can sell it out certain product, I can even distribute it out certain products through process for the longer period of time. So this is my exclusive rights, whatever said as it is my exclusive rights, I can exclusively import from this goods to the some other way for the longer period of time. So this is what where the patent parallel it has been said. Now applications here it has been given here as if we are doing once we completed with the help of applications, the date now all the patents shall be dated as of the date on the which the application for the applicant was filed under the existence of the provision of the patent. So it has been said that all the patent who want to get it registered, they need to file it according to the Patent Act 1956. It has been said for the 1970 they need to file it out. And the second part, it is the major changes to compulsory publications of an applicant, except those related to the efficiency after the period of 18 months, till which time will be kept the secret. So this is what as if like whenever you're getting registered itself, so it will be compulsory. The thing is once you get it registered, so that registrations you need to keep it for the longer period of time. Means once you're getting an application, once it has been accepted or you need to accept the applications, and once you get it the application, once you get it the applications, that only you need to file it, and once you get it the applications you need to file it for the longer period of time, that will be received with the help of then 18 months for it. Okay, so like this is what an application has been said, or it is the date, whenever you're doing an application, from that day only the thing is it has been mandatory, it has been accepted of. Next it is what with the help of the next it is what where the patent applications. The inventors will also have the necessary has to ask the examiner of his applicant without a period of 48 months from the date of filing. This toleration period for the lapse patent is extensive from the 1 year of 18 months. So here it is what if there is any kind of people. Okay, if the people is filed about it, means once it has been filed from the date whenever it has been filed, from that date till 48 months, the thing is it has been valid there. Now once you are doing an application, that applications like whatever the patent, whenever it has been prepared, that patent you need to submit it to the people. So then afterwards they'll be checking out, they'll be examining out each and everything. So within the 48 months only they'll be giving you the license, and once you get the license, it may be extended till 18 months. It can be extended till, it can be lapsed till the period of in 18 months which has been there. So once if you're completing out that thing, so it takes a longer period of time to wind it up with an applications one. Now what is the next way where then applications here like your it has been given does not applicant if it has been withdrawal in between, if it has been withdrawal, so ultimately that thing it won't be applicable, like whatever it has been, it will be stopped on that time, it won't be moving further. Then afterwards, if once you're getting an public, once you're getting a patent, whenever it has been registered, so ultimately that thing what you need to publish it out into the certain way, you need to perform it out into the certain rules and regulations. Means you need to inform to the each and everyone when related with any kind of it like innovations. If you done it out, means certain documents, certain advertisements you need to do it out. So then afterwards, once it has been done, then only you can perform that kind of it applications which has been done for the patent. Next, it is what when related with the patents. Now, if there is any kind of oppositions, if the interested parties, if they are doing out, this will also help in interesting the parties, makes and depth studies of each of such material in the case of oppositions and revocation procedure. If any of the people is like agreeing for the decision, so then afterwards whatever like opposing out, if there is revocations or any kind of opposing out, so why it has been opposed or why it has been applicanted out, that all information like it to be submitted to the patent according to the Patents Act 1970, like whatever it has been said. Then earlier only the complete specifications was to be filed with the detail of the site, books, etc. So like whatever the details, whenever you're getting out that details, you need to file it out into a certain book. Like once if you're doing an applications also, that applications one, it has been fulfilled out. That applications forms also means as if you're getting a license. So before that license, when you renew it out, they need to just copy it out. They need to keep it out for that for the people. For, and then after they need to mandatory, they need to register, they need to keep an application where the thing is the application it has been passed it from one person to the other person, means as if I grant a patent license to the other person, then our application is to be filed it out for that. Then after license rights. Now here it is given the some sections where it has been given where the license are having the rights. The provision for the license of a right. This provision is provided that upon the applications of a patent would be endorsed by the license of a right. It reasonably requires to the public where not means. Okay, it will be an explicit right, means a person rights it will be. It won't be for the public rights, it will be for the personal rights where the thing is, he will be saying, yes, I need to perform that way and I want to perform that kind of license as I get a license into my hand. So I have that much right to accept it out each and every provision according to the sections like whatever it has been given. So like according to the sections like according to the patent rights, license for the rights that is being given section 86, 87 and 88 are omitted into it. So that the thing is what the certain provisions are to be omitted and certain provisions are being accepted for the longer period of time. Next it is what license for the rights. Now it has been continued. Also the patents are for the invention capable of being used of the food, medicines as we have seen into the current slide also. Once you're getting a license of, means you get the license for the food, medicines and drugs also, because this is also the one type of process which is new, which is different where you're getting out. Okay, so that is why this also the drugs and all as well as the chemical substances were deemed to be endorsed as a license of the rights after a period of 3 years from the date of expiry of sealing of the patent. Now this will not be the case. So this is what if there is like you get it the right for this, even you get a license for the there for the food, for the medicines, for the drugs also you get it you get it out. But the terms like what they give to you, and the license rights like whatever till 3 years till the 4 years like whatever it has been given. So till that only it has been to that only it has been accepted. After that it has been expired. So like whatever it has been related with the help of the food, medicines or drugs, you need to follow like certain, even for the certain chemicals also, you need to follow that kind of substances for the longer period of time. If that thing all it has been mentioned, then ultimately the thing is the license, whatever it has been given to you, that right is applicable. There are compulsory license it is being said. Now working with the of innovations in India, it makes the ground of compulsory license. Now when related with the help of, now it has been said, like common if you don't have a license you can't do any kind of work. So that is why it has been said when related with the help of the when you are running with any kind of patent, so So like compulsory you require the license, that is most important. Okay, and then afterwards the internal for the people like who are big into the patent also. Okay, the patent after 2 years. Now it has been said, and also the non-working of a patent in India shall be ground for requesting the controller for revoke the patent after the 2 years from the date of the first compulsory license for granted. Now as if like if that person is got once that person has got the revocation, so that revocations directly won't be getting out the revocations, like as if they given the revocations it will be mentioning about it. So once it has been mentioning about it, it will be getting 2 years of like people 2 years of patent, for 2 years from the date of the first compulsory of the license, like the day when you get it out, and then afterwards still 2 years the thing is it is invalid, and once the 2 years it is been completed, it will be revoked it out, it won't be worked. So the controller means the main authority person only there, that person only will be getting out the destructions. Then afterwards the compulsory license is also getting about it like 90 and 95, the sections that is given. Reasonable requirement of the public failures to the manufacturing in India is not to be considered for this purpose. However, corrective license packages to be considered for this purpose. Now when related with manufacturing, it has been said, means where you're developing certain kind of it like manufacturing by developing certain new things, certain chemicals and all. First it has been said it should be not there. But when it has been given to you, but when related with packaging also, what the packaging also you require the license from there whenever it has been issued. And next it is what where it is a non-exclusive rights also. Okay, the compulsory license shall be non-exclusive, non-accessible, and the pre-denominated for the Indian market. Now, according to 95, it has also been there where certain new rules and regulations which has been given to you. So that the thing is, it won't be assessing more, it won't be assessing less also whenever it is being given for the license for the longer period of time. So it is like a non-exclusive rights. If it is been not there, then too the thing is you need to have a mandatory license for that, because that person is having the exclusive license for it. But that license, which is what for not for the longer period of time, it will be for the shorter period of time, because as if your product has been delayed for the Indian market also. So that is why in the next term it is what when any condition the nature of granting back prevention of the challenges to the validity of a patent and corrective packaging licenses contract and license of patent shall be unlawful and unvoid. Means if without license you are running with any kind of business for the longer period of time, so it won't be like that the thing is it has been registered properly. If this kind of it will be, so it will be treated as unlawful, and where it will be even treated with the help of the void, where void it has been said null and void, there is no rules, no regulation if it has been effected up. So like without getting a license, then only the thing is you can perform your duty for the longer period of time. If you're not getting out, then afterwards that kind of it's the one type of challenges, and that challenges you need to wind it up. If the challenges it has been fulfilled out, then only you can work it for the longer period of time. So license is the compulsory mandatory for it. Now, here it has also been given about it like by getting compulsory license accepted in the case of national emergency, extreme urgency, public or non-commercial use for anti-competitive practices adopted by the patentee, controller has to take into the account where the applicant for the compulsory license has been afforded for the obtaining for the license of the patentee for the commercial terms and conditions, whether such effort is not to be successful with the help of the reasonable period. Means as if it has been said, if you're getting a license, compulsory license, as if you're getting out, so that will be with the help of all terms and conditions. But as if like you're getting certain kind of it emergency or any kind of it like anti-competitive word, so like the thing is the people, the controller who require that kind of it should be having the longer period of time you need to follow those rules and regulations. Then only the thing is you can move it for the longer period. It will be successful then only. Till the time if it is not there, so ultimately it won't be successful. So like you need to follow the mandatory, like whatever the license whenever it is being given to you, so that license you need to follow. And then after miscellaneous, it is being said as if I said to you, like you are having one type of an applicant board with the ratification powers of any kind of board. So like as if you are having a one type of an applicant board where the thing is you are having you can file the case with related with the help of high courts or any kind of courts whenever it has been there. So like whenever you're filing any kind of case, so before 6 months, like whenever you're getting out, so like before after the period of 6 months only the thing is you need to record all those details, and once you're recording all those details, like the period of 15 months from the putting of the applications in order, the date of the statement of an object issued by the controller is to be reduced within a 12 months, and the provision of extensions is being deleted. Means within a like 15 months only the answer will be getting out, within a 15 months only, but within a period of 15 months for putting the application order from the date of a statement of an object. If it has been like the whatever the objections has been given to it, and then after that objection like mandate, if you have given to on that time, so within a like they won't wait for more months, but within a 12 months only they have been completed out this matter. If there is if there won't be any extension, then ultimately the thing is, if the extension of the time is been deleted, the time where the extension where they have to wind up the case, that has been deleted. So that is why the thing is the applicant needs to be rectified the power. Means they need to keep that kind of it to rectify each and every power. Okay. Now this was first when related with the help of like a patent. Now we'll be moving with the help of it rights, where it has been said with the help of the copyrights. Now copyrights, once it is what, it's one type of legal protections for an author of original working of authorization, including literacy. Now these are the categories where it has been come, like literacy, where it can dramatic, musical, artistic, and a certain other intellectual or other intellectual words. Now this all the way where it has been termed with the help of the copyright. So that is why it's a one type of a legal protection for the author for the original work of the authorization. So this is what where you're converting certain music variations, or else wherever the thing is where you're showing any kind of pictures into it, or as if you're showing same kind of pictures, you're visualizing that thing, means which is new, which is different. As if you people are aware with this, currently only we have discussed about the matters which has been related, where the thing is you are having the rights, where the thing is where in the movie it is when there if you are dubbing into the like some simple individual like any regional movie, means this is what the movies will be same, the variations will be same, but the thing is internal the talking of it, the depth of it will be like something, means it has been dubbed. So that dubbing, it is what a copyright, like as if whenever if you're doing a copyrights also, now that is also now as if this is a one type of an exclusive right. Now, as if when you're dealing with the copyrights are one type of an exclusive right, where the thing is you're showing certain innovation, means as if it has been there into the Hindi movie, you're dubbing into the like some regional movie. Okay, or else where you can even see the what it where the olden times the movie when it was coming into that. Okay, what was the olden time when the movie was there? It was a one type of black and white. Okay. It was one type of it where it was a black and white movie, and currently the thing is that was like currently as if that black and white movie only you can say it, or you are getting certain kind of it like colors into it or something else. As if you people would be aware with the help of Mughal Azam, like previously it was with the help of like black and white it was showing out, and currently with that also we get it out with the help of the colors. So this is what means the same it is. We are making the same copy of that, but you're developing certain kind of exclusive rights, certain kind of innovative ideas you're showing about it. So this is what where a copyright it has been there. So mostly basically it will be dealing, so that is also one type of intellectual individual property rights, where the thing is you are will be dealing about the original work of an authorization, where the different category literacy, dramatic, musically, and artistic, where you are showing certain kind of innovations. Now, what works are protected? Now, as if it's a one type of a tangible form expressed, means it's a fixed where it has been set. You can see it out, you can visualize it out. So then afterwards, the thing is the fixation needs not to be directly perspectable so long as it may be communicate with the help of the aid of machines and device. So this is not like it has been fixated with the certain people, but the thing is what directly it has been communicate with the help of certain kind of new machines or certain kind of a new device whenever it has been fixed out, and then afterwards you are showing that kind of work with the help of certain new ideas, certain new things where you are commencing out with the new thoughts into it. So this is what one type of it like expressing the fixed, one type of a tangible form, one type of a different form you are showing about it. Next afterwards it is what once it is what it's a one type of an original work of authorship, meaning that the work must be independently created by the author, as opposed to the copy from the other work, as it has been said now, it's the other work how it has been formed. So here I just only given one topic, which is the US require level of originality in is very low. Other countries' law may differ into the respect. Now, when related with way with the help of as we people are aware with it, now as learning with the help of so many rules and regulations, so many law, we people will be aware about it like in each and every system, in each and every set of rules and regulations, each and every state, each and every country, not even state, each and every country, the rules and regulations are different. The way of like developing any kind of copies or any kind of a different logo, any kind of a different terms of copying out or same to same variations, if it is being given, this is being something which is new, which is different, it is being said. So it is one type of it original, once it is, it's the original one, authorship, and then afterwards that original we are just copying out and we are developing new certain new developments with this. And how the cartoon also how we are seeing about it now as they are visualizing and then after they are performing out. Then after what are the categories? As I said to you, what are the categories comes into it? Literacy work, musical work, sound recording, like where the thing is you dub that song into like the some other person says, and after there's some other song which has been said something else. Then dramatic world where you're showing out, choreographical work where it has been shown, pictographical graphics and sculptures work, motions, apertures, architecture work, and all. This all comes into the protected work where it has been there into the copyright. Means this is what are different terms where the same script it has been mentioned with the help of the Hindi version. As a same script again we are mentioning about it to different kind of it languages or different kind of it variations. Then this is what something new which is innovative ideas and that person is having the exclusive one that yes I have prepared it out this type of it like for that the thing is the people will be aware about it the new way as we got to know about like new conversations of it. So means already it has been there, but little bit type of it variation it has been inbuilt it out. So that the thing is what little bit type of it variation it has been inbuilt it out. So at least what each and every people's right it has been influenced on. Now, for this also like whenever copyright it has been protection, it has been secured automatically upon the creations. Means as if how you cannot do copyrights like anyhow. It is what as if you're developing certain new things, and once you're developing so new things, then afterwards you're showing certain kind of a creation, certain type of creativity into it, and then afterwards you're changing certain type of a new exclusive ideas into it. Then afterwards no publication or registrations is required. You don't require the mandatory for this. Like if you require also like the permissions you require from the government that is in there. But the thing is what you don't need to publish it out to each and everyone. It has been there for the small applications you need to fill it out. Now as if you people will be aware about the registrations also. No. Simple it has been there about it where the thing is as if you have seen any kind of movie. Now before the movie starts, you get it one certificate which has been given from the government. That is called a central board sense of it, where the thing is, where this movie goes over there, and then afterwards where certain kind of it like new development, certain kind of a new thought it has been given to that person. So ultimately, if there is certain kind of it variation, if it has been shown, then ultimately the thing is that thing they have been done. So like whatever it has been sought or if it has been which is going opposed to it, so ultimately they cut it out that thing and then after they give the grading for the movie also. Now next it is what the copyright owner must first file the application like once as if I done any kind of it like copyrights as if I develop. First it is what I need to like file it out. Then I need to pay the fees like whatever it has been given to it, like whatever the fees it has been given. Deposit the copy of work of a copyright office. Some of the office must be added to the collection of the library of the congressee. That is what which has been said. Like as if I need to just develop certain kind of a new copyrights, and then afterwards what is the invention if I do it out? The new invention I need to submit out to the people. So as if I develop with the help of registrations, I need to file it out. Once I file it out, what are the fees is then that fees, and rest of it like whatever the copies I have developed it out, the copies I need to deposit on that time. So this is what people will be doing on that time, like they will be performing about it. Now, why registration is most important? Why registration? Registration it is what to know about it. That the thing is what if the thing first most important if it has been registered, then after a certain period of time, as if you are showing any kind of it rights into it, it won't be affected, which has been like, which has been protested, where it has been there. If there is certain kind of it, then afterwards it won't be showing that way. But if it has been, if there is certain illegally performing on that time, so ultimately what you can do it out, you can file the case to the court. You can file the case to the court if there is certain kind of it like which has gone beyond to the law, or a certain kind of it illusion is in there, then after you can file the case. But that is why, so that is why it has been said like registration is most important. If we are following any kind of a disadvantages into it, so ultimately if we are following certain kind of a disadvantages to it, so like what you can do it out, like you can file it the case to the court, and then afterwards like whatever the fees during to this matters, it will be affected on that time. So that will be each and everything, it will be done. That kind of each and everything, it will be also done about it. So as if I just given a little bit differentiation with the help of the Indian court also, and even with this little variation with the help of the foreign court also. So here it is what the able first, second point is a prerequisition for obtaining statutory damages and the alternative fees, like whatever it has been the alternative fees. Then easy to enforce our copyrights in the foreign courts. Put others on the notice. Earlier to license work, collected the royalties and enforce your rights outside to the court. Like once if you're doing the registrations, you are having a certain rights that this copyright I have performed it out. So then once it has been done, then afterwards you are the owner of it. Then no notice is required. Okay, it is like once you are preparing out, then no notice is required. You are getting one logo. Like whenever if you're doing a copyright, you are getting a one logo which is in like that. Like it will be C and it will be round. You will be having a circle, and in the circle it will be have this a C. So with this you can identify the word copyright, or in a brief word is a cropper, your applications and the name of the copyright owners. Like as if you went with any kind of it, like as if you see any kind of serials or any kind of movie. Once you are winding up with this movie, you get this kind of logos where you get it out. Means you get it this logo, and with the help of this logo only the thing is you show certain kind of a new thing. Means I have developed certain kind of a new ideas into it. So that is why that thing will be what happens, it will be mandatory, it will be possible for each and every people to get it, like yes, it has been like whatever it has been done, so that thing will be what it is mandatory, it has been said yes, like whatever it has been done, the registration is true and fair, and whatever the copyright whenever it has been prepared it out, so that copyright which has been there, which has been new, which has been developed with the form of it. So this logo, it is important whenever it has been dealing with the copyrights. When you are developing certain kind of a new technique, certain new innovations that has been given to it. Next, it is what the terms copyright. Now, what for this, like whenever if you're getting registered, it is for the longer period of time. If the person die also, then the thing is the copyright, it has been moved for the longer period of time. It is not like as a person, like certain period of if the person dies, so the under the thing is the copyright doesn't work. Means whatever the innovations you have done, it is for the longer period of time. So mostly happens this thing into the copyright, like you have the life plus which has been there for the 70 years. If the in between the 70 years the authors die also, there's certain kind of it variations and all. Now how you can say a musical instrument, like as if the person who has been like visualizing with the help of like you can say a painting, whatever it has been there, certain which has been new innovative ideas whenever it has been created out into the painting. So like if the person dies, will still the painting live alive. So this is what the innovations which has been done. So that innovations, the thing is after the person die also, that certain it has been there for the longer period of time. And then afterwards it has been there, if the author is not a natural person, natural person, then the copyright endure 95 years for the publications or 120 years for the creation, whichever expired the first. So this is what the variation, mostly the 95 it has been, sometime it has been happened, but usually the thing is 70 years which has been given if the copyright it has been there. For the means as if it is given for the patent, it is for the 20 years, it has been given permanently for the 20 years for the registrations, like you get it that kind of it like registrations, and even with you with this you get a 20 years, 20 till 20 years, the thing is it has been having the validity. The same when related with the copyright also, you are having a 70 years validity for the longer period of time. Then only you can use the help of the terms of copyright. Now, as if you will be learning about it, the ownership. Now, who will the owner of it? Ownership of a copyright. A copyright initially belongs to the individual authors. Okay, means he has been copyright. Who is a person? Copyright is what the individual person. Okay, means he has developed certain new ideas. That's it. Then joint authors are co-owners of the copyrights into the joint work. Like as if for the copyrights, if there's a two or more people who work together and they develop certain new copyrights or develop certain new techniques, so that is called a joint authors, which has been said. Under the work made for the higher doctrine, the employer is the owner of the copyrights for the work creation with the scope of the employer. So that is why if any of the person is hired for that work also, and that work which has been done for the longer period of time also, means they are developing certain kind of a new owners. Means the person who is an author, that person becomes the owner of that copyright since he has developed certain kind of a new developments into it. So this kind of it, then afterwards that thing is also there. Then after special rules apply for the commissioned work. If it has been there for the commissioner work, then certain kind of a new technical work which has been given to that work. So ultimately that kind of is a special, there are certain rules wherever it has been given. So you need to follow that kind of rules which has been there for the differentiated on that time. Then after transfer of an copyright, then any or all the copyrights owner exclusive rights may be transferred, but the transfer of exclusive rights is not valid unless that transfer into the return. Transfer of the rights of a non-exclusive base does not require the return agreement. Now it has been said, first the thing is you can't transfer. If a certain period of time that person, first and most important, it's having the exclusive rights. But if certain period, if they want to transfer it out, that copyrights from one person to the other person, so the first most important that requires to be into the return. If it is there into the return only, then only the thing is he can just sign it out, and then afterwards it will be valid for the longer period of time. If it has been not signed, then ultimately the thing is it has been not at all valid for the longer period of time. So that is why the thing is, if the term is the transfer of a copyright, first you require one type of it where it should be returned, at one type of it where it is a non-exclusive rights, it is non-exclusive rights. If it has been not given to it, if you are transfer of the rights on the non-exclusive base, does not require a return agreement. Now, if you don't want to, if it has been transferred but a certain way, the thing is you don't require any kind of a return agreement, but if there is certain kind of exclusive rights which is in there, you want to transfer it out, then afterwards you require the return rights also. Then afterwards, the copy of infringement, it has been said. If there is any kind of it related with any kind of a case relating with any of the people who has been filed according to this, and who is creating certain kind of it like infringement into it, then after he can file it out that kind of case to the longer people or to the infringement, you can file it out that case also. And once you're filing out that case, the thing is because it is being seen about it. If there is, it goes to that person's only right, then ultimately that person will be getting a certain kind of it rights to that. Then after, what are the elements of in copyright infringement case? Now what are the things that will be coming out when you're putting any of the person into the bars or any kind of a case whenever you're handling any kind of person whenever keeping about it? First, it is what a validity and the ownership of the copyright, means who will be the author and what the validity of it. If it is not proper, so I can file it out that kind of case. Next, it is what wrongfully copying of the protected expressions, means whenever I was doing a copying. So on that time, like what the thing was there, and second part, the thing is what I copied next time. So this thing I need to see it out. If there is any kind of it like as if I seen about it, means wrong copying if I done about it, then afterwards it won't be useful. If it has been wrong copied, then also if I file the case, so it has been wrong. Means without not taking a permission of any of the person, I copied out. So then afterwards it will be treated as a wrong way. As if I want to copy down and I want to develop certain techniques. So first important, it is what I need to develop certain new ideas into it. So if there is a case like first, if I don't have a license, and second part it is what, if I'm wrongfully copying out, then ultimately the thing is that type of rights doesn't come. Then what are the limitations and exceptions? These are the exceptions where it is being said. First, the sale of doctrine. Okay. Next, it is what special effects exception for the librarians, achievers and people. Then afterwards, creative statutory license, creation of televisions and radio exception, reproduction for those who have disability, single software copy for the achiever purpose. Now this is all the exception. These are the limitations where these are the disadvantages where if you're performing with the help of libraries, you're taking out or any kind of activities related with the teachings and or any kind of a different terms whenever you're taking about it. So if this type of it variations, if you are taking out reproducing something new, different techniques and all, if you are taking out, so there is having certain kind of fit limitations where you not need to perform for the longer period of time. You need to just wind it up for the shorter period of time only. If the single software, the same software only you're developing with the new ideas, and the software says something the same thing, and the same software says something else thing. So if this kind of it is, then ultimately it won't be moving for the longer period of time. So if there is certain means you need to develop certain kind of it exceptions into it. If there is certain kind of it exceptions where it has been restored for the longer period of time, then only the thing is you require certain kind of it changes. If it has been there, then only you can perform it out. Then this are the certain kind of it exception which has been set for the disadvantages. Then what are the remedies, means as if you're getting a copyright once it has been get for the infringement. So like where the thing is when you get it the remedies, where you get it the advantages, where you get it a certain kind of it like advantages, or whenever you are recovering out your whatever the debts it has been there. First, actual damages, statutory damages, injunctions, including temporary and permanent injunctions, impounding infringement copy, destroying the infringemental copies and machineries and equipment used for the products, and attorney fees and attorney fees and the cost. Like whatever the amount it has been there, whatever the damage it has been there, for which has been related with the help of the copyright. So that all copies. Then afterwards, whatever the court interventions, whenever it has been given, and during the court matters, if your matter goes to the court, and then afterwards, like whatever it has been given to it, like this right, it is not at all accepted, this right is not accepted out. If it has been given like that, so then afterwards, that type of it, what you can do it out, like whatever the compensations, whatever the recover they have been said during to that process also, that also you need to what that type of remedy also you get it, and once you get it that kind of remedy, you can wind it up that type of copyrights also, and whatever the fees you require, what are the costs has been required, you can just recover it out on that time, because that's a one type of it remedy where you can recover it out your each and every system for the longer period of time. So that is why this type of it is also been given with the help of the copyright remedy. Now the next term that has been related with the help of trademark. Now as we went with the help of with copyrights, we went with the help of patent. Now these are the two different rights where we learn about it, the different terms where we are following certain new ideas, certain new development into it, like we are following according to the Copyright Act as we are following according to the Patent Act 1970. So like the both acts we followed means where we have seen certain intellectual ideas, certain new ideas we have seen. Now the third chapter, now the third point you will be learning about it with the help of the Trademark Act. Now the Trademarks Act was there in 1999. We need to follow here. We follow certain rules, certain regulations when related with any kind of logos. With the help of what do you mean trademark? It is what certain kind of logo, certain kind of symbols, certain kind of a design with the help of like any creativity when it is being shown, and with the help of this creativity we are identifying about it whether what type of goods it has been there. So this is what with the help of basically which has been there for the trademark. So little bit this is which has been given little bit introduction of trademark. The British regime in India, the big merchants and the businessmen who has been established their mark. Now this was done with the olden period of time where like they have shown certain kind of a mark in the market in the respect of certain goods under the particular brand name, styles. Now what are the trademarks which has been created out with the help of brand name, style, design, felt? They should be continuous to be sold or a traders under the same brand name, style or a design, or and no other person shall be allowed to adopt that brand name, styles and design. Now, as if you have seen about it, the cars whenever it is when they, like Audi, he's having the different brand. The Mercedes brand, they're having different kind of brand. Then after the ambassador is having different kind of brands. Means that with the help of logo, with the help of like brand only, we can identify it's an Audi, it's a Mercedes. Means with the help of design only. As if we have seen with the help of it like. Any kind of it clothes whenever you're buying out, any kind of it like jewelry when you are buying out, you are having a certain kind of it logo. So basically this act which deals with the help of like you are having with the help of brand, with the help of name you are identifying out, with the help of logos you are identifying, with the help of style you are identifying, and then afterwards you are utilizing for the longer period of time. This kind of it the product. So as if you're not thinking about a shorter time, but as if you're thinking about for the longer period or for the certain new creative. So this is what, as if I showed certain kind of a logo, as if I shown a certain kind of logo, it says this is the brand whenever it has been there. Now as if I said now arrow short. So as if you can see like short back side, you can see a one type of a tag which has been there. So in that tag, it has been mentioned about it. It's an arrow shot, whatever the number it has been there, and then afterwards the logo it has been there. Means it has been stick that kind of logo. Means as if the brand, the value it has been given. Now you're paying the cost for the brand, not for the short. You're big, because you know it like short. It is like arrow short. It is like a popular short. It is a good short. But with this, the thing is you're giving the money for the brand, not for the short. So that is why the brand saves. And the thing is, the main basically for this chapter, it is what, as if like whatever the brand it has been there, the same brand it is not copied by some other else. Like whenever, if you're going with the any kind of logos, whenever you're getting out, each and every companies and each and every product, each and every service, they're having certain kind of logos. With the help of a logo only, we can identify. No. As if it has been said, now the Taj. The Taj means they are having certain kind of crowns whenever it has been saying about it. So with the help of that Taj only you can identify it's a one type of a reputed restaurant where the thing is you are having a like a good and a clean way where you can have a food also with the proper way of it. So this type of means the basically a trademark which has been dealing with the where you're getting certain where you're getting certain new innovative ones where you're developing one. So this is what this type of a trademark where it has been done with the help of the Britishers on the olden period of time. Then basically what you mean by trademark? A trademark is a mark where related with the goods for the purpose of indicating and connection between the goods and the person has the right of the proprietors to be used the name. Now here also it has been said, what do you mean by trademark? It is what a certain way which connects with the customers and even to the people who reproduce the goods. There's the two connections where it has been shown. Now where as if I'm giving you the branded clothes, the people will buy the branded clothes. Means with the help of the trademark only the people are buying the clothes. Either if I don't have any kind of it amount, then only the people won't buy the clothes. Means there if I show certain kind of it like new technical into then only the people will buy the clothes. If it is I don't show any kind of a technical one, then afterwards the people won't buy the clothes. So this is all what a trademark is, basically a connection between the goods and the customers. So that the thing is the people will be getting about to know about the branded of the clothes. And then after this one which is new, which has been developed with a certain kind of innovative idea. Now as if you have seen about the BlackBerry, what a logo it has been there. For what is there for the HTC, what logo is there? For the Apple, what logo is there? Means every logo depicts something which has been new, which has been innovative. And if when you're registering this type of trademark, if same type of logo it has been already existed out, then ultimately the thing is you doesn't get the trademark register. Means you need to develop certain kind of a new development. If same it has been there, it has been not at all developed it out. Next afterwards, it is what, second point, it is what, it has been visualized, it has been labeled, like whatever, like you can visualize, like whenever it has been short or any kind of it, pants or any kind of it, like article, whenever it has been there. So like you can see a logos which has been visualized. And while seeing any kind of product, we can visualize. Means a brand, it is a trademark. It is what which has been visualized with the help of with the help of symbol of any kind of an organizations or any kind of companies, which has been good. And then after it has been the visualized. It is not for the individual one. It is for the public. So this is also one type of it. Like what is mean by trademark? One type of it is been there. Then afterward, what are the functions of trademark? A trademark surveys the purpose of identifying the sources of or the origin of a goods. Trademark performs the four functions. Now the four functions, the thing is a trademark identifier. First it is what products and its origin. That person, now what do you mean by trademark? It is what one type of an identification where you can see the product and its origin, means how it has been basically whenever it has been dealing. Second, it is one, it shows the guarantee of the quality. Guarantee its quality, means as if I say a brand is the word, means a quality where it is for the longer period of time it will be. Then afterwards it's advertise the product. It's advertise the product into the market, and then the trademark represent the product, and even the thing is it with the help of logo, the product it is being represent to the outside of the people. Then afterwards, it shows certain kind of an image of the product in the mind of the public, particularly the consumer or the prospective consumer of such a good. Means it shows certain kind of a new techniques to each and every people. So with the help of this new technique, the people get attracted whenever they're buying any kind of clothes. So these are the four major functions where the thing is the trademark whenever it has been registered. So these four major functions has been there for that way. Then after mark not registered. Now here it is what if why when it has been not registered, your trademark is not registered. If it has been having certain kind of a confusion, means if the trademark or any kind of logos or any kind of single, it means if it's been same, so that type of it has been not at all registered. And if the thing is what the mark the use of which would be contrast to any law for the time being was, means if it is the same a parallel one, if it has been showing to it, so if that kind of it has been shown, then afterwards the thing is for the time being force it won't be accepted out. So these 2 points which has been there, so like the trademark it has been not at all registered. It is not at all registered at all for the longer period of time. It has been not at all registered. Next it is what a mark contains a mark comprises or contains the standardized and options matter, means certain kind of illusions it has been shown, certain kind of a different it has been shown into it, so that mark is also not at all it has been registered. Next it is what certain kind of it hurts with the help of religions, okay, or any class of sections where means if you are drawing any kind of mark where you are showing any kind of religions to it, any kind of class of sections when related with the help of religions, if that kind of it has been shared, then also you are not getting a way where it has been not at all registered to that. Then afterwards, as if it is not protected the court of law, means as if you are drawing certain kind of a logo and it is not protected with a certain kind of law, that also mark it is not at all registered. And last but not least, it is what no. The mark which has been identically, which has been deposed similarly to the trademark already registered in respect of the same goods or a goods of the same description. So it has been said if the goods already been existed out and the same copyright, same I have what I've done are the same trademark, same logo I have been copied once again. So if that type of it has been there, so ultimately that thing is also not at all registered. So like whatever it will be same way how I need to follow it out. If the same it has been there, if it is if it is went beyond to the law, like whatever the logo it has been there, if it is went beyond to the law, or as if it has been showing any kind of it like identifications to it, if any kind of it not description it has been shown, if this kind of it is, then ultimately the thing is it won't be moving for the longer period of time. So like whatever the trademark it has been dealt on that time. Then afterwards the if there is any kind of it words which has been accepted the name of the single chemical name or a chemical compound in the respect to the chemical substances, means if it is dealing with the help of certain kind of it chemical one, okay, that also it has been not at all registered, or certain kind of it class or second kind of it sectors or certain kind of it tribes it has been there, means for example geographical name, means if this kind of it category if it has been coming over there, then afterwards it won't be getting registered out for the longer rate. Now, this act it has been basically dealt with the help of 1999, as you people are aware. Now, the main definition of this widely it is one with the help of color combinations and shape of the goods. Now, how you identify with the help of how you drawn with the help of trademark? First with the help of color, and second with the help of the shape. Like you show the shape, like certain part of it oval you showed, certain way you show the square, certain you show the rectangles way, and with the help of it you are doing any kind of it innovatives into it. So that type of it like you can show it. So with the help of this only you can identify the trademark. Then afterwards, what is a service mark? Service mark it is what where any kind of schools, any kind of hospitals, or any kind of it finance, any kind of it education here. See certain kind of it here it has been given. Banking, communication, education, then after fire, finance, insurance, cheat fund, real estate, transport, storage, material treatment, process, supply of electricity, or any kind of it means entertainment, amusement, construction, repairing, any kind of information and all. They're using different kind of it service trademark, means as if whenever you are into the trading into it, so they are showing certain kind of it mark which is in service oriented. Okay, it is benefit for you, so for the people who are service oriented, who are providing you the service, for them the thing is you are keeping certain kind of it service mark which is being set. Next, it is what the collective mark. Collective mark, it is what where the Indian family, now the collective mark has been provided for the benefit of the members of association of the person. Okay, and such inclusive collective marks will be benefit for the tradition in family's trademark. Means as if you are being into the home, as if you're being into home, you are having certain kind of collectivity of the different marks into it. Means you're developing a certain new marks for as if you are there into home. So like you show the certain kind of a tags to it, the certain kind of a tags you are doing out. So means if that kind of it, if you are doing out, so that is like one type of a collective marks which is in. Then there are different types of mark. As if we people was aware with the help of it, like service mark, trademark we was aware with it, we were aware with the service mark, we are aware with the collective type of mark. Next it is what well-known type of it mark. It is what well-known treatment. It is what where you're showing certain kind of a new segments into the different types of department, and where certain innovative ideas you are showing out, and that is the innovative ideas which is good for the each and every people for the newer generation for the longer period of time. It has been well known, it has been popular to that type of trademark. So then afterwards the renewability, it is what the renewal for the registration of a trademark should be made for every 10 years. Every 10 years you need to register, you need to what, you need to renew it out of 7 years under the present of the act. Now into it, like now in between, like within 10 years, in the 10 years, in between only 7 years, the thing is, according to this act only you need to renew it out, and if you are renewal it out, and then afterwards further you can move it for the longer period of time. So that type of renewal should there. Now who can apply? Who can apply? Like single individual person who can apply for it, any kind of a proprietor or any kind of a people who are owning, who are like running with any kind of small limited kind of business. Okay, the application may be made in the name of an individual partners or a firms like corporations of government or department of any kind of it. Means the applications can be made it to the any name of an individual persons to any kind of it like governmental person, where the thing is because to get a trademark, you are having the people, the government issues a trademark, and with the help of the trademarks he gives you he gives you the trademark, and the registrations he gives you on that time. And with the help of registrations, the thing is you can run with your certain kind of a shape, certain kind of a logical terms to it. Then after the applications, now here also you need to give the jointly you need to give the applications for the people who are being into the government, where you need to just file it out the documents, and then after you need to just submit it out that kind of detail. And once that you're developing out this certain kind of detail, that application form with the help of it, like whatever the logos you have developed it out, that kind of logos, you need to show it, you need to explain it out that kind of logos, you need to get it out that logos, and then afterwards once they'll be like clarifying each and every logos, and once the logos or any kind of symbols, if it is been the first time only it has been applied now, then only the thing is it will be registering out. If it has been same to same the copy it has been done, then afterwards it won't be there, done without. This is one type of the application one. Then afterwards every application of registration of a trademark shall contain a representation of the mark in the place provided in the form of purpose. 10 additional representative marks has to supplied with the help of application. Means internally the people where when into the organization, they need to also give this type of representations of a mark. So at least what each and every people will be identifying out. So at least the people will be getting the help of the awareness that how they need to run with the help of the trademark, and how the applications whenever you're getting out, and how you wind it up that kind of applications to it. Now then afterwards use the submissions of an application for the registration of the trademark. There should be the 4 outcomings. These are the documents you need to submit it out. The application is accepted. Now once you complete it out with this thing, the submission to out, it has been accepted out. Once you're getting the acceptation, your what a subject mention amended into it, then afterwards later it has been founded to be, if there is any kind of it error, if there is any kind of it rejections to it, then ultimately the thing is they inform it to you. If it has been rejected, then too it has been then too the thing is it has been like it has been given into the return way why it has been not at all accepted. If it has been accepted, then too it has been mentioned on that time. So this is what is being given for the help of an applications whenever you're performing about it. Now once you're getting completing with this thing, then afterwards what you can do, you're developing any kind of product, and with the help of developing any kind of product, you can show certain kind of an advertisement, like you can show that brand to the any kind of it articles or any kind of goods. So at least what the people will be getting about it means when you're getting an application, when you're getting a registration to it, So within that registrations only, the thing is within a 3 months you need to show with the help of it, like when you are developing any kind of goods or any kind of it like services when you're providing a, so that logo you need to pull it out, and then afterwards you need to wind it up that kind of logo, and you can advertise that kind of logo also. So the time period for this, it has been 7 years. After 7 years you need to renew it, that has been said. Like once you get it the registration for the trademark, so within a seven years only, the thing is you need to registering out, because it is validity till it is for the 10 years, but they have been said that within a 7 months or within a 7 years only you need to register, so that the thing is furtherly there won't be created any kind of it errors or any kind of barriers into it. So like you need to just wind it up that time or whatever the period has been said. Infringement, it has been said here, if any of the person during registration is copying out with the same to same means already that logo it has been already existed out, and same again you are registering also, ultimately you can file that type, or the person can file the case to the court. So like whatever the service mark, or whether it is the general collective mark or with no trademark, whatever the mark it has been there. So if it is moving for the longer period of time, or else if it has been like said, so that this matter you can put it into the court, and then afterwards whatever the court will grant a permission to like to give the license or not to give the license, or to take a further actions or not, that will be occurrence on that time only. Then about the essential of infringement. First, like when you want to put it out that kind of matters, so what do you require? First, it is what the take of an essential features of a mark, or taking the whole of the mark, a few additional alterations would constitute a free. Like means whatever the mark it has been given to you, whatever the trademark it has been associated with to you, then afterwards that trademark you need to show it out. If there is any kind of it alterations, if you are showing out, then afterwards means if there is the same logo whenever it has been depicted to you, so if that kind of it has been there, then afterwards it won't be used. If there is not that kind of it has been used, then afterwards only it has been used it out. The fringed mark must be used in the courts of the trade. Okay, that is regularly traded wherever the proprietor of the mark is engaged. So like wherever if it is given to you for the means, if you have done certain kind of changes into it, so if that kind of mark whenever it has been given to you, so that kind of mark you can put it out, and then afterwards the thing is the proprietors can use that kind of differentiated marks into it, and then afterwards they can start it up with the business. Next, it is what the like whenever the market has been given, it should be printed out, it should be visualized to it, so that the thing is that when giving the advertisements or like drawing any kind of invoices or any kind of bills, so it is like not orally the trademark it has been done, the trademark it has been, so orally like you can't say like put the case into it, like this is not a way like as if you put it up. So as if you require the proper, it should be a written way where you can visualize, where the people can visualize it out, and then after they can wind it up with the matters of it. So if this kind of it is in constitute, so ultimately the work won't be moving further way. Then after the above all, any or all the above act will constitute the infringement. If it has been not done, so ultimately the thing is finally you can wind it up with the help of the, like you can do it with the help of the court, like whatever they will be granting the permissions to, then and afterwards you can perform that way. Then afterwards, what are the remedies you're getting about it? Like whenever if there is any kind of it matters, like the proprietors who is dealing with any kind of matters, the trademark has the right to file the suit. As currently only we have learned with the help of infringement. If any kind of it like where it is like disadvantages they're performing about it, so we have that much right to sue that person. You can file the suit also for that person for the infringement for the rights. Then afterwards for the injunctions. The defendant from using the offending mark pending the trials of the suit or until the further orders. So if there is certain kind of it illogically, if it has been shown about it, then afterwards the thing is you can show certain kind of injunctions on that time, you get a remedy. Then afterwards whatever the damage, whatever the loss, like whenever you're getting about it, any kind of it certain way, where it has been damaged or which has been injured to any kind of person. So that type of it, like as if like whatever the loss it is, you get it the remedy on that time. Whatever the infringement it has been done, like whatever the loss you get it out. So that all thing which has been covered up into where which has been there with the help of the remedies where it has been covered. Then afterwards the account of profit. where a painful claim the profit made by the unauthorized use of his trademark, it is important to assess to what extent he trademark is used in order to determine what proportion to the net profit refers to the interest for the attribute. Means if it is like not redeemable it out, if it has been moved for the longer period of time, then ultimately the thing is whatever the profit was incurred during to on that time, it can be claimed that kind of profit by rest of it like issuing the certain part of a trademark. So like whenever if the person claims for the profit, so that unauthorized use of trademark, the people doesn't use means which is being not at all like as if we are putting our money, but as if it is not used for the longer period of time means it is we are like you're not getting any kind of permission till the time. So like whatever the profit, like whatever you get it on that time, you need to calculate out that kind of profit. Then after there are some questions here it has been given to you. So what are the like trademarks and all? The same like what we learn currently. The same it is like a small type of questions here it has been given. What is a trademark? As we people got to know like it's the one type of it visualizing the symbols and all like branded names and all whenever it has been given. Like it is a one type of identifying the product name as if it is for the product name and product brands and product qualities. So with the help of this only the thing is you can identify the goods and you can buy the goods as if it has been given that kind of qualities also. So this thing is also there when using with the help of the trademark. Next what which has been related, what is service mark? As currently only we have learned about it, what is service mark? Now it was according to Service Act 1999 it has been said about it that the one type of it like currently only we have learned this thing is a one type of it like chit funds and all this type of questions. So that is what you can refer this type of questions during examinations. It will be like good for you. So that is why I kept certain kind of it FAQs questions that is called like you can find it out the questions also. With this, if there is that kind of registrations, then afterwards you can do it. Then afterwards, like without the why it is compulsory. Now whether the question here is given whether registration of a trademark is compulsory under this act, it has been said no. Registration of trademark is not compulsory, but for the better protection, it is advisable to get it registered for the trademark. Means as if any of the person wants to develop any kind of logo, it is free for you. It is not like you need to register that kind of trademark. But if you do, if you like get it registered, then ultimately the thing is you get it the better protections also. So that is why, as for my advertisements, it is what it has been said like as if you registered the trademark as if you registered the logos and also like it will be good for you also to get it certain kind of a remedy if there's certain kind of furtherly if there's certain kind of it like problems whenever it has been occurrence into the business life. So that is why like whatever the trademark it has been there means it is not mandatory like it is not required permanently to get it registered. How your copyrights and patent it has been get it registered because it's a certain kind of a new innovative one. So it has been said compulsory you need to do the registration. But for this, the thing is, it is like if you don't do the registration, then it's also okay. But if you do, then it will be the better one because what as if you want to file it out any kind of case, if any of the person ditch to you, and then afterwards if you want to file the case also, so you can file the case. So then afterwards you get it the certain type of remedy according to this act also. So this is the one type of questions. Then afterwards, how to acquire the right of the property in the trademark. How you can say by the property is mine. You are having the three questions, three answers which you are having out. First it is what relating to the particular goods. As if you can say this good is mine. This is my goods. Like as if you are identifying the goods, you can say like this is my good. Next it is what as it has been registered according to act. So like you can say yes, this goods is mine. I have developed certain kind of it. New ideas, new properties into it. Next, it is what by transmissions of the one person to the other, like as if you're transferring one rights to the some other person for one times to the some other person. So that is why this is what where you're showing certain kind of a new techniques into that. Then afterwards you can say this property is my property. Now whether user is very important or very important in a trademark, yes, user means it is what the person who has been registering out. Okay, so does that person is required? It's important to use a trademark, yes, because what as if I'm developing certain new logo. So if only I'm only not using out, so like what's the use of it? So means the user who is obtaining, who is developing any kind of goods, so does that person is available? Yes, that person is like available and that person needs to be registered also. That is also important for this. If there is any person who is not agreed to do the decision, agree to file the case. So then afterwards the thing is what, you can file that person, you can sue that person for it, that this person is not ready to do the registration, because the registration is most important for this also. Next it is what, is it possible to file the trademark applications on the ground of purpose to be used? Yes, like as if it has been said now, as if you want to file the trademark application, so it is like as if, but the application should have the bona fide intentions to use a mark at the time of filing application. Because what, as if means, as if it has been said means, why you're getting registered? Because what, as you get it registered, so it is what will happen, like you're accepting that kind of logo, you're accepting that kind of trademark. So that is why you're accepting out. So the thing is what, as if you're accepting out each and everything, then only the thing is you're filing any kind of case, and your application, it has been filed, all for your application, it has been filed also. So that is, if there is this kind of it, then yes, it is possible to file the trademark application on the ground of purpose to the person who has been using it. So like you can file it on that time. So if this kind of it is, then afterwards ultimately the thing is it won't be created any kind of it negative impact. Is it possible to get registered trademark without any interventions of to the use? No, it is like no. Because what, as if you don't have any kind of use of any kind of product also, then how the thing is, it won't be get it registered. Means, as if you are not having any kind of intentions to use a trademark, then afterwards it is not required to be, it is not required to be registered also. If it has been used, if it has been used for like, if you will use, then only it has been required. If you are not using out, then afterwards it does not need to do the applicant for to file it out any kind of case. And then after, whether the proprietor of an unregistered trademark can initiate the legal action? Yes. If there is any kind of legal action, if any person, if on that time during like doing a registration, as if it is like any of the person ditched to you on that time, if on the any ground, if it is going for internally or criminally, if it is performing about it, then afterwards you can file the case. If that person is reaching out to you, if that person is performing very negative way on that time, then afterwards the thing is according to the civil code, because this type of it matters goes to the civil way, where you are filing certain kind of it case to it, so that you will be getting the compensations, or whenever you are passing out certain kind of a new regularity. Then what about the renewal of the registering trademark? As we have seen, like minimum, like within a 7 years only it has been calculated, or within a 7 years means as if you are having a 10 years, but within a 10 years, like it has been said, but 7 years it has been compulsory. Within a 7 years, the thing is you need to renewal the registered trademark. It is. Will any rights be conferred upon the applications on mere filing of trademark applications? No. As if the thing is what, will any rights to be conferred upon the applications on mere filing of trademark? No. Any other no rights which has been affected, because like without the applications, without the trademark, without the filing any kind of it, the thing is till the time you are not filing an applicant, it will be registering, it will be having certain like rights which has been affected. But if it has been not, if your applications it has been done, then afterwards not a single right will be affected on that time. So then afterwards, so this was a simple point. This was in this point where we went with the three concepts. Now, like here, this chapter it has been winded up. Now that is why we are learning. We have went with the three chapters. We learned with the help of like little bit. I'll just summarize to you, so at least what you people will be able to answer it out those questions. So as if in the trademark we learned about it like a huge concept where you are developing with the help of logos, where we are with the help of certain kind of symbols, certain kind of new techniques and all that of it. So that is why the IPR, the intellectual property rights, which deals with the which deals with the five concepts. But in this five concepts, the three major concepts is most important. So that's the main three concepts which has been dealt with in your syllabus. So there are five concepts you people should be aware about it. It has been given with the help of it. Like what do you mean by intellectual property rights is what? Intellectual means individually a property. It means a property means it is he has created certain kind of an innovative idea, and then afterwards he is having that right. That means I have created certain new and certain innovative idea. So in this IPR we are dealing with five concepts which has been dealing with the help of copyrights, patent, trademark, then after design and last with the help of the geographical indications. If my five concepts has been there, then afterwards ultimately this property, certain kind of it, property rights which has been affected on that time. And then afterwards we went with the help of it starting, we went with the help of patent. So in the patent also we have seen according to the 1970 the act it has been said, you need to follow certain new terms and condition also in that. And then afterwards internal, you need to go like where the thing is you are harassing any kind of microorganism, any kind of plants or any kind of it like animals or any kind of trees and all, if you are destroying out and you're developing out certain new techniques, if that kind of it is, so ultimately the thing is you can't perform, means your patent it is not at a register. So in the patent where like whenever you're getting registered, the important thing it is what which has been new, which has been different, which has been innovative, and that person only has prepared it out. The same thing, it is not like that the other person has prepared it out. Means if there is certain the same thing it is been prepared, but you are showing certain kind of innovations. Now currently as we learned with the example of a refrigerator also, we are having a refrigerator, but something which is new, which has been innovative. Single, we are first time previously was having a single door. Currently, we are having a dual door or a trial door. We are having about it. We are having like cupboard. We are having out, and within like 10 minutes or 20 minutes, like the ice cubes, it has been ready. Then after the same, you doesn't get that variation which is there on the Samsung. You get a different variation which is there on Whirlpool. So that is why. And that brand which has been there, the stamp and sign, it has been done with the help of it, like logo whenever it is in pen, like Whirlpool or in Samsung or in Onida or like any kind of Videocon, whenever it is it's a different way where they are showing about it. Now as with a different way, the amount also, the cost also of the product will be different. The main intention of this patent it will be what which has been new, which has been different, okay, where the thing is you're not destroying any kind of it like organism and you're reproducing it. And then afterwards it's a one type of an exclusive rights, like whatever the rights you're learning about, the three rights you learned about here, that's one type of patent, copyrights and trademark. The three of them rights is the one type of an exclusive means, and certain innovative rights it has been there, okay, where you're dissolving out like certain terms into it, into like you're moving into the detail, and like whatever the rights, once you're getting your patent, whenever you're getting registered with an applicant from the state government, and then afterwards you get a 20 years, till 20 years the thing is your application it has been like possible. Once you're completing with your 20 years, then afterwards again you after 20 years you need to renew later. So this is the main concept when dealing with the help of the copyrights. Then when dealing with the help of the patent. Now the second part we will move with the help of the copyrights. Copyrights, as we have seen, means where you're visualizing something new, certain kind of it artistic which has been new, certain demographical it has been new, certain geographical it has been new, means where your musical instrument has been different, your literacy it is different, means certain new it has been there, and there you're showing any kind of a dubbing into it, or language or any kind of regional language you're converting about it. So that all the things also you require the mandatory to get it registered with the help of the government. They give you the license. As if we even learn about it, like they was giving about it like a certain way where they was giving you the certificate, as if I shared you this thing also, no, that once if the movie it has been released also into the theater, the previously you can see one type of it like certificate which is given from the central board film. Means if it has been like certain illusion, if it has been there, so like that doesn't continue further. If it has been not proper, so if it has been proper, then after they continue further. So for this also you require certain kind of it mandatory to be registered with the certain type of it government. So that afterwards that is called the one type of it copyright. The same it has been there, you are dubbing and you are developing certain new things. So that is why basically this is one term of the copyright. Now the copyrights, which is like one type of, if the author died during the time, means if the author is died, then to the thing is the film is also been there. Then to the thing is the concept is also there. It is not like the person dies and the thing is the concept is being changed. So it is like when the person dies, also the concept is being still alive for the longer period of time. So this is what one was. It was this type of concept, and it has been given that the registrations whenever it has been done, it is still 70 years. Means like whenever you do an applicant, whenever it has been registered with the help of copyrights, it will be for the 70 years. It will be till the time it will be for the more time. and then afterwards we'll move with the help of the trademark. We have completed with the help of the copyrights. Then we will be moving with the help of the trademark. So as if trademark is the one type of logo, okay. So like your, if you do the registration, then also it's okay, and if you don't do the registration, then also it's okay. So like, but they basically said about it when you're doing with the help of trademark. So like, if you do the better way, if you do the registration, then only the thing is it will be better way. If you want any kind of it, like you want to file the any kind of case or any kind of suits on that time. So it will be good if you are having a certain way where you're showing certain kind of it, certain kind of it, if it has been registered, you're showing certain kind of logos, certain kind of symbols, certain kind of it articles on that time. So if this type of it has been there, then only it will be registering out for the longer period of time. Because what, as if a trademark, with the help of it brands, with the help of logos, with the help of symbols, you're buying any kind of article, you're buying any kind of properties or any kind of it, like any kind of it brand. Because as if I said, you know, you're paying the money for the brand, not for the clothes or not for the, like, as if you're seeing the quality, and you know, like, this is a brand, and with the help of brand only the thing is you're accepting of. Okay, so this is the way. So that is the, and for this also, like, minimum you require, there's a 10 years for the license. Whenever you're getting out, it's a 10 years, but within a 7 years it has been said it's a compulsory, you need to renew it every 7 years. The thing is, a trademark should be renewable about it. Means it has been here, it is what, if you do